morning. Court will advise counsel that we will break the case after perhaps the first hour and then resume after a 15-minute break. Sofie versus Fibreboard et al. The party's ready.
Thank you, Your Honor. May it please the court. My name is Paul Stritmatter, and along with William Rutzick, we represent Austin and Marcia Sofie. In addition, Brian Harnato is here on behalf of the Washington State Trial Lawyers Association. I will begin our presentation taking 18 minutes with a summary of our position, a brief review of the facts, and an examination of the traditional approach to the equal protection issue under the Privileges and Immunities section of our state constitution. Mr. Rutzick will follow me for 20 minutes with a presentation of the first argument in our brief, the jury trial issue, and he will present the issue of joint and several liability under RCW 422070 and other trial issues. Mr. Harnato will conclude with 12 minutes of discussion on various fundamental rights under our state constitution, how they apply to RCW 456-250, and a brief review of how Oregon has been analyzing state constitutional issues. If the court so pleases, I will begin the Privileges and Immunities argument, and the jury trial and other issues will await the presentations of Mr. Rutzick and Mr. Harnato. It's an honor and indeed a privilege for me to stand before you and in part present these important issues to the Supreme Court. But as I do so, I will tell you that I'm scared. I'm scared not just because of the responsibility to my clients, the Sofies in this case, but because of the responsibility I have and the burden I carry for the people of the state of Washington who have been the most seriously injured over the past 26 months as the result of the negligence of others, and for the people of the state of Washington who will suffer the gravest and most severe injuries as a result of the negligence of others in the future. The future well-being of those handicapped, scarred, and paralyzed people weighs on my shoulders, and that burden scares me. The legislature in 1986 passed RCW 456-250, which placed a cap on non-economic damages, limiting the rights of the seriously injured, the elderly, and those who are married or have other dependents. It is our position that the cap on damages violates several provisions of our state constitution and should be struck down. This is an extremely important case to the injured people of this state and those who will be injured by the negligence of others in the future. Those Washington citizens who will be injured in the future may not even know at this time the profound effect this case will have on their future well-being. Most state courts who have faced the issue of legislatively mandated caps on damages have struck them down as unconstitutional, relying upon basic constitutional guarantees of the right to trial by jury, equal protection, due process of law, and separation of powers. In this lineup of legislatively mandated limitations on recovery by injured people, the Washington limit is greater than that of any other state except North Dakota under the facts of this case. And that North Dakota statute has already been declared unconstitutional. I refer you to the chart behind me, which shows the greater recovery that would have been allowed to Mr. and Mrs. Sofie under the statutes of all of those states. Many of them, however, have already been declared unconstitutional. This lawsuit and the statute in question touches upon a number of fundamental rights or fundamental principles enjoyed by the people of the state of Washington, as well as other very important rights of the people of this state. We propose an analysis and application of the Washington State Constitution to strike down this statute, which is supported by either a traditional federal analysis approach coupled with the application of Washington state values, or a strictly Washington state analysis of its own constitution. Let me explain why these are fundamental rights by looking briefly at the facts of this particular case. Mr. Sofie was a 67-year-old former pipe fitter who was exposed to asbestos insulation products that were manufactured by these defendants. He contracted mesothelioma, a cancer of the lung, the linings surrounding the lung, because of his exposure to asbestos fibers. As a result, he suffered from excruciating and exquisite pain in the chest and a progressive shortness of breath. The progress of the disease totally encased his lungs, slowly, but literally crushing him to death. He was maintained on pain cocktails and morphine. Every 3 hours during the night, Mrs. Sofie would administer pain medications and get her husband in and out of a bathtub because the hot baths were an attempt to alleviate some of the pain he was going through. Mr. Sofie was in fact too ill to attend this trial. The average life expectancy is 9 to 12 months after the diagnosis of this insidious disease, but there was evidence at trial that Mr. Sofie had a life expectancy of 22 more years. The jury awarded non-economic damages of $477,200 to Mr. Sofie, and the jury awarded non-economic damages of $677,390 to Mrs. Sofie. The trial judge, in ruling on a motion for a remittiture by the defendants, specifically found that the jury award was reasonable and well within the evidence that was presented at trial. However, the court was compelled to reduce the jury award because of the legislatively mandated remittiture to $51,681.35 for Mr. Sofie and $73,455 for Mrs. Sofie, pursuant to RCW 456-250, or a total of $125,136.45. As we begin a constitutional analysis of this cap, I would remind you this court is not the critic of the legislature, but it is the guardian of our Constitution. It is the duty of this court to declare acts contrary to the Constitution void. Without this, the rights and privileges reserved to the people of this state would amount to nothing. At the investiture of Justice Smith just a few weeks ago, Jack Dean, the president of the Washington State Bar, read the following quote: "More than any other branch of government, the judiciary provides for and protects the have-nots of society. It guarantees fair process and insulates minorities and others from oppressive laws that would only benefit the rich and powerful." This court stated in Dennis versus Moses that the people need protection from the hasty acts of the legislature, and state constitutions are designed to serve as a check on those acts. In analyzing an equal protection argument under the traditional approach, the first issue is the level of scrutiny to be applied. The heightened scrutiny, or mid-tier scrutiny test, recognized and applied by this court in State versus Phelan, should be applied in this case, because the statute involves a sensitive or discrete class not accountable for its status, and the statute involves an important but not fundamental right. The courts in New Hampshire, in Carson versus Maurer, in North Dakota, in Arneson versus Olson, in Idaho, in Jones versus State Board of Medicine, in Kansas, in Coburn versus Augustine, in Ohio, in Duran versus Suburban Community Hospital, all have applied this heightened scrutiny test to strike down caps on damages. Tort victims who suffer great pain and catastrophic injuries are a sensitive class. It's a politically powerless class, it lacks group cohesiveness, and is politically disorganized. The number of victims is not great for widespread public concern, and the victims themselves are at their most vulnerable and weakened state after their injuries. Compare this to what became known as the Coalition, a well-organized consortium headed by insurance companies that pushed this legislation through. A group spearheaded by insurance companies who our Attorney General has concluded were engaged in an illegal conspiracy to attain tort reform. These are the pleadings signed by our Attorney General under Rule 12, joining this action, which was prompted by what one Attorney General said, and I quote, was the most insidious consumer fraud perpetuated upon the American public in decades, end quote. There are 62 pages of specific allegations against the insurance industry and indicating that they conspired in an attempt to change the tort laws across the nation. Further in analyzing the level of scrutiny, the statute involves important rights. As stated in Hunter versus North Mason School District, the right to be indemnified for personal injuries is a substantial property right, not only of monetary value, but in many cases fundamental to the injured person's physical well-being and ability to continue a decent life. Liberty is very precious to us in this country. As a result, we apply a heightened scrutiny standard in reviewing legislation that affects a person's physical liberty when a discrete class is involved. However, I submit to you that the freedom from pain and injury and the just compensation for those injuries is much more important than physical liberty. It is a more important right to receive adequate compensation for a young person trapped in a quadriplegic body for life, who needs funds for necessary care to avoid being left in a nursing home, than it is to avoid confinement to a prison for life. It is a more important right to be adequately compensated for the loss of a leg so that you can properly support a permanently disabled life than it is to avoid confinement in jail for a year. It is a more important right to be adequately compensated when you've been negligently blinded by another so that you can fill your life with worthwhile endeavors than it is to secure credit for time actually served in jail against discretionary minimum terms, a right recognized by this court in State versus Phelan as requiring a heightened scrutiny review. One of the moral philosophies, the underlying moral philosophies embraced by our Constitution is our belief in the dignity of mankind. The concept of non-economic damages relate directly to the fundamental belief in the dignity of life. In Hansen versus Williams Company, North Dakota in 1986 said, in applying heightened scrutiny, "We believe our focus must be on the individuals affected. We are unwilling to view human life and safety as simply a matter of economics." The important right of adequate compensation for personal injuries inflicted by the negligent conduct of others demands a heightened level of scrutiny under this statute. The cap in this statute violates equal protection for three reasons. It discriminates between the more severely injured and the less severely injured. It discriminates against Mr. Sofie and other elderly people based upon age or life expectancy. And it discriminates against those who have spouses or dependents with loss of consortium claims. Under the heightened scrutiny test, a classification must be reasonable, not arbitrary, and rest upon some ground of difference having a fair and substantial relation to the object of the legislation, so that all persons similarly circumstanced shall be treated alike. Well, the most severely injured plaintiffs are impacted the most by this statute. If the award is less than $125,000, there's no effect at all from this law. If it's above that, the injured party must rebate the award to the tortfeasor. The greater the injury, the higher the rebate. The persons thus most deserving of compensation are affected the most adversely by this statute. An award of $1,154,590 in this case to Mr. and Mrs. Sofie was cut to less than 11% of the jury's determination of what was a fair and just verdict. It is simply unfair and unreasonable to impose a burden of supporting the availability and affordability of insurance on the most severely injured. Under any test you apply, the statute discriminates based on age. The statute does not apply alike to all members of the class, and there is no basis for reasonably distinguishing between those within and without the class. The jury will have already taken into consideration the age of the plaintiff in reaching its verdict. The jury is generally instructed, and the jury was instructed in this case, to take into consideration the life expectancy of Mr. Sofie. But this statute reduces the award once again based on age. There is no rational basis for this arbitrary factor to be injected again. Age or life expectancy is certainly not relevant for pain and suffering in the past, and it shouldn't be in the future if that factor has already been factored in by the jury in determining its verdict. There is no rational relation to this classification to the purpose of the statute. Few awards for persons in excess of 60 years of age that exceed the cap, and the record is that there were only 3, for instance, in 1987, that could not possibly materially affect the affordability and availability of insurance in this state. The classification by age does not assure the adequate and appropriate compensation for persons injured through the fault of others, which Section 100 of the Act says is a purpose of this statute. As stated in Arneson versus Olson, when the North Dakota court struck down their cap on damages, the limit on damages does just the opposite of the stated purpose to provide adequate compensation. There is no rational basis and no rational relation to the goal of creating more affordable insurance when there's no evidence before the legislature that there would be any reduction in costs. In fact, the filings with the insurance commissioner since the passage of this act have indicated that the new law will have no effect on rates. In Roberts versus Johnson, this court was confronted with the question of whether to retain the gross negligence standard in a host-guest context, and this court said, the suggestion that one class of injured persons should be forced to accept their loss without compensation in order that the public generally can enjoy lower insurance rates is not appropriate. Such a proposition is hardly compatible with principles of equality. And lastly, I would point out there is certainly no rational basis for reducing Mr. Sofie's pain and suffering award simply because he was a married man. It is irrational to limit damages of a person physically injured because he has a spouse or children or other dependents who may also have suffered a loss, and then permit a larger recovery to those who don't have any such associations.
You have used 18 minutes.
Thank you, Your Honor. This statute is also unconstitutional because it violates the right to trial by jury guaranteed by Article 1, Section 21 of the Washington Constitution. Mr. Rutzik will address that issue and others.
Good morning. The constitutions of Florida and Kansas and Texas all provide that the right to a trial by jury, quote, shall remain inviolate, close quote. Same language as in the Washington Constitution. Within the past year and a half, the Supreme Courts of those 3 states have pointed out that caps on non-economic damages violate the respective jury trial provisions of those states' constitutions. The Oregon Constitution, from which the Washington jury trial provision was, I believe, taken, also provides that the right to jury trial shall remain inviolate. Within the past year, the Oregon Supreme Court held that a state provision that limited the right of a jury to determine damages would violate the Oregon right to a jury trial. They didn't actually hold that it did because they interpreted the statute in such a way as to make it unnecessary, but their initial holding was that it would so violate. These decisions are completely consistent with this court's prior analysis of the right to a jury trial, and we suggest that this court follow the rationale of these four courts. I'm going to turn in a moment to the Washington cases, but before doing so, what I'd like to do is to use these cases I was just talking about to demonstrate how they refute what I view to be the defendant's primary argument. I take their primary argument to be an analogy to the workers' compensation law, which was dealt with by this court in the Clausen case and several others, and also to the automobile guest statute, which was dealt with in the Shea case. What I take to be the defendant's position is that they're saying, since the legislature can completely abolish a cause of action, it therefore can limit a jury's ability to award damages under the cause of action. That analogy is flawed for several reasons. First of all, we do not agree and do not believe that the legislature could constitutionally eliminate the right to all non-economic damages, flatly say it's not there. But perhaps more importantly to this case, they didn't do that. They did not eliminate the cause of action. They maintained these actions as actions at law and simply tried to restrict or tamper with the jury's right to award damages. This court has on numerous occasions adopted the principle that even though the legislature doesn't have to do something, if it does it, it has to do so consistent with the Constitution. For example, the legislature very likely today could eliminate unemployment compensation as a program. It's a federal aid program. If they wanted to, they could eliminate it. But so long as they are undertaking the unemployment compensation program, they can't impose unconstitutional limitations on it. They can't say that somebody who for religious reasons won't work on Saturday can't get unemployment compensation. So the principle is there. Now, with regard to jury trials, the Oregon case, and the case is called Maladith versus Truck Insurance Exchange, and it's cited at pages 33 and 34 of our original brief. But they deal in the jury trial context with this precise issue, and if I might, there's two excerpts I'd like to read on it. They say, and this is at page 996 of the 744p second, they say with regard to this situation, it is conceivable that another procedure for settling disputed insurance claims could be substituted for a contract action, as has occurred with some other formerly contractual disputes. But as long as this form of dispute is tried as an action at law, a jury trial is required. And that's precisely the issue here. They then go on to deal with, well, what does the jury trial have to encompass? And then on the next page, they cite a California case, which represents the California analysis of these matters, which is not, I've submitted in the brief, the Washington analysis. The Oregon court disagrees with California and says, with regard to whether a jury has to determine damages in the factual context of the case, this reasoning is unpersuasive. Our Constitution provides that the right to jury trial, quote, shall remain inviolate, close quote. This right includes having a jury determine all issues of fact, not just those issues that remain after the legislature has narrowed the claims process. In many instances, the amount of the loss will be the only disputed issue. I submit that is essentially the analysis that this court should follow with regard to this precise statute. Turning to the Washington cases, if I may, I've talked about them in the brief, and I just want to allude to some of the more, the ones that seem more important. The first case, when we're talking about, well, the first case is James versus Robeck, in which this court made clear that the right of a jury to do stuff, to determine stuff, isn't simply to determine facts in a vacuum. Rather, this court said, to the jury is consigned under the Constitution the ultimate power to weigh the evidence and determine the facts. And the amount of damages in a particular case is an ultimate fact, which is reserved for the jury. So what a jury does in Washington is determine what the damages are going to be. That is the traditional and long-standing interpretation of the jury trial provision. Now, an early case which illustrates this, I think, quite well, and again it's talked about at some length in the brief, is the Dakers, that's D-A-C-R-E-S case, which was decided by the Washington Territorial Court before the adoption of the Washington Constitution. In that case, the legislature had, for what it determined to be good reasons, to provide a cheap remedy, I talk about a cheap, fast remedy, had taken away from the jury the right to determine damages. And they gave it to an arbitrator or an appraiser. What the Territorial Court did, and this was less than 6 months before the Washington Constitution was adopted, is Section 5 of this law, which was called the Railway Fence Law, basically says that the appraisers determine the ultimate fact of the damages. The Territorial Court said it's unconstitutional. As we understand, at that time it was the Seventh Amendment because there was no Washington Constitution. As we understand the Constitution, you can't do that. Now, I mentioned in the brief that a plurality of the framers of the Constitution were lawyers, including some judges. They were very well aware of what the understanding was of the right to a jury trial by the Territorial Court at the time they adopted the Washington Constitution. This is clear evidence of the understanding of the framers of the Constitution at the time it was adopted. The other cases, again, they're talked about in the brief to some extent. I'll mention the case of State versus Strasbourg. And the importance of Strasbourg is several-fold, but perhaps the most important is the very eloquent and I submit persuasive discussion of the fact that a jury trial's got to mean something, that it's not simply a charade or a game in which the jury goes through the motions of doing something that nobody pays any attention to. And they quote a black unconstitutional law, which basically says it's evident that it would be entirely feasible for a state legislature, if so minded, to impose such onerous and oppressive restrictions or conditions upon this right as to make it practically unavailing to a party for his protection, yet without denying it an express terms. But this would be a palpable violation of the spirit and intent of the constitutional provisions, and the court would hold any such restrictions upon the right as not less unconstitutional than the total denial of it. And I submit that's exactly what's happening here in this court. Simply should follow the rationale of Strasbourg. The only other case I'll mention, and this is not very explicit in my brief, so let me make it explicit, a recent case of this court, Pasco versus Mace, which is a case involving the right to a jury trial for individuals who face any kind of jail time, essentially. And the significance of it, not only did this court go beyond the federal the federal protections of jury trial, but what this court did was make it clear that the right to a jury trial is available to anyone who is facing jail time, even if the law under which they were arguably going to go to jail was adopted 5 years ago or 10 years ago. Because there was a suggestion in one of the briefs that somehow the right to a jury trial only protects the exact right that existed as of 1889. And this court and the U.S. Supreme Court has made clear that you don't look to see whether the exact statute is identical between 1889 and 1988, but rather you look at, is this the type of matter which was subject to a jury trial? And in this case it is. Let me then turn to another issue, turning away from the constitutional issues, and turning to a statutory issue that is also involved in the case. This simply is a copy of the relevant portion of the statute. I thought it would make it easier for a discussion. Now the issue here is an interpretation of the 422.070, which says nothing in this action affects any, nothing in this section affects any cause of action relating to hazardous waste or substances or solid waste disposal sites. Now the trial court here found that the Sofie's action was covered by this provision, and did so in a manner I suggest is entirely reasonable. Essentially, what the court did is he first said this section is in the disjunctive. That is to say, to fall within this section, it has to be a cause of action relating to either hazardous waste or hazardous substances or solid waste disposal sites. And that's what or means. And I don't take it that, I don't know if that's subject to dispute, but that's obviously what or means. He then says that asbestos was a hazardous substance. Now, his job was made easier in that regard because the defendants conceded that. And it's talked about at the record. They concede that asbestos is a hazardous substance. And that's consistent with the dictionary definition of a hazardous substance, and it's consistent with the various statutory definitions. And then finally, he said, well, what does relating to mean? Because there was an argument that, well, yes, it's a hazardous substance, but this action relates to design defect. It doesn't relate to asbestos. And he utilized this court's definition of relating to in the Snowden case, which is a 38 Washington 2nd, in which this court essentially utilized a but-for analysis. That is to say, a matter relates to something if but for that something, the action wouldn't be there. And it was essentially undisputed that but for the asbestos, Mr. Sofie wouldn't have contracted mesothelioma and the action wouldn't have been necessary. I submit that that's a perfectly logical and clear interpretation of a logical and clear statute. Now, the defendants basically don't like that and raise a couple of arguments that I'd like to touch on. One is they say, well...
Let me raise one additional point on that I don't see you touch on or counsel for the defendants. As I understand, RCW 422.070B retains joint and several liability against the defendants in cases where the plaintiff is not at fault. The jury has found that this man is not at fault. Is this even an issue?
It's a two-part test, and let me see if I can explain it. With regard to, as I understand it, by the way, and it's been a while since I didn't look at that specific point, but the way I understand it is with regard to the defendants in the action, that is to say, the actual defendants, if the jury finds the plaintiff without any fault, then there is joint and several liability with regard to those defendants in the action. Okay. On the other hand, it's my belief that unless one of the three exceptions, which are part of subpart 3, apply, then with regard to persons who the jury would find are at fault, but who are not defendants in the action, that as to that claim, it would only be several. That is, if the jury found it was 80% these defendants, none the plaintiff, and 20% somebody else, my understanding is that if they find that the plaintiff isn't his fault, that 80% is joint and several, but not the remaining 20%.
So it's not a factor in this case at this time?
And that's right, not at this time, that's right. The issue, depending on the result of what the court says, might come up. But I think it's fair to say we still have to face an interpretation of this section. Now, basically what the defendant's argument boils down to, well, they really meant, the legislature really meant the Superfund. And section 70, RCW 70-105. And I guess the point I would make, and I think the trial court alluded to it as well, is that if they had meant this just to apply to the Superfund, they would have said so. It's easy enough to simply reference the statute or say Superfund legislation or whatever. But that's not what these words say. These words say they have a plain meaning. The defendants also argue, well, you should look at the legislative history because the statute is ambiguous. The trial court found, and I think I've tried to explain why, that the statute isn't ambiguous. The statute's clear. So there's no point at looking at the legislative history, which, as our brief points out, is itself ambiguous. I mean, this is a case where the statute is clear, and there's no need to look at ambiguous legislative history. Then there's also a discussion, well, there's some principles of statutory interpretation, which I believe is pronounced ejusdem generis, which should be applied in this case. And we in our brief, it's a fairly technical area, and talk at some length as to why basically the language here doesn't lead itself to that. And the prime case on that is electrical contractors, this court's decision in electrical contractors versus Pierce County. Now, turning briefly to the trial issues, the defendants claim that the court improperly excluded a witness by the name of Carl Mangold. And
Before you get to that,
surely.
could you discuss another concept regarding the interpretation of the statute? On the one hand, when you're looking at this from a deprivation of jury trial, you can say that it is the job of the jury to establish, in fact, the amount of the non-economic damages. This is subjective. And if you take away that particular job of the jury, you're depriving a person of his right to a jury trial unconstitutional. On the other hand, there's another way of looking at this statute, that the fixing of jury awards is at best a subjective endeavor. And so what the statute does is it simply sets up a guideline. It sets up, much like the Sentencing Act, some sort of standards by which a jury is guided to reach consistent verdicts in different varying situations. And that if this is so, it really is not a deprivation of the right to a jury trial, but simply, and maybe this is a fatuous statement at this point, but it simply gives the jury some guidance by which it can reach appropriate results in a subjective area.
Well, if I can address that. Obviously, it's more than guidance. I mean, it's a mandate. It's not a suggestion. It's a, no matter what you do, we're going to take it away. But the point I would make is the common law and the law in Washington in 1889 was aware of the potential for mischief or abuse that you're talking about, and there was a way of dealing with it, and that was essentially the judge's right and duty if the to insist on remittiture or a new trial. In other words, it was a fact-based thing. If a judge determined that, given what are admittedly subjective standards to some extent here, if it goes out of bounds, what a judge would do in 1889 is order a new trial or order a remittiture. In fact, the Kansas Supreme Court, in the case I talked about earlier, the Bell case, says that essentially what this is a pre-established, inflexible remittiture that happens regardless of the facts of the case. That was not the way jury trials were done in 1889. And regardless, in other words, I understand one might differ as to whether it's a good idea or not, but the jury trial analysis, I submit, isn't so much, well, is this a good idea? Could the legislature have thought it was a good idea? The analysis is what was it like at the time of the adoption of the Washington Constitution? And there was no such thing as a statutory remittiture.
You have used 20 minutes.
Okay. let me use about 30 seconds. Basically, with regard to Carl Mangold, the important issue that I want to talk about or to mention is that the judge did not, in fact, limit his testimony except with regard to one issue, which is simply what Mr. Mangold himself did at the shipyard. And the judge's ruling is precisely on point with this court's ruling in the Miller versus Staten case talked about in our brief. The defendants were absolutely free under his ruling to have Mangold talk about what's referred to as state of the art. That is what everybody knew or didn't know of the case. There is no prohibition about that. They simply refused to call her, or not refused, they chose not to call him and used another so-called state-of-the-art witness who accomplished the same thing. So the narrow ruling of the trial court was correct, and the defendants then picked up and accomplished what they claim in their brief to be their primary purpose through another witness, a Dr. Demopoulos. I think that there are a couple other things I should save them for rebuttal. Thank you.
Good morning. My name is Brian Harnato, and I'm here today on behalf of the Washington State Trial Lawyers Association, which filed a friend of the court brief in this case. It is a privilege to be allotted 12 minutes of time on behalf of WSLA in what is one of the most important civil cases to come before this court in 100 years. I think everyone will acknowledge that the court's decision regarding the constitutionality of 456-250.
Mr. Hart, no, the light went on showing 5 minutes left, but I think we can assume that's a mistake, and you'll be allowed.
I hadn't seen it, Judge. I hadn't become alarmed yet. I think we can say that whatever happens here with regard to this case will probably set the tone for constitutional analysis for the next 100 years. Given this magnitude, we pondered long and hard over what we could say in these 12 minutes that might be of assistance to the court in addition to answering any of its questions. And we concluded that it might be appropriate to begin with a response to the question posed by the court for which it allowed the parties supplemental briefing regarding the Oregon Privileges and Immunities constitutional analysis. As you know, Washington's Privileges and Immunities statute is almost identical except for the additional reference to corporations. We believe that the remarks regarding the Oregon analysis will also have relevance with regard to other constitutional theories that have been addressed in the briefs. For there is a common thread here that I think transcends any single constitutional theory, and that is a subtle or perhaps not so subtle assault on the notion of non-economic damages and both the jury's and court's ability to render reasonable awards for those type of damages. As I talk further of the statute in light of the Oregon Privileges and Immunities analysis, I would ask the court to keep in mind what the preamble to Chapter 305 says is the legislative intent. It talks about, quote, reduce costs associated with the tort system, unquote, but then it says, while assuring, quote, adequate and appropriate compensation, unquote, for injured persons. The intent was to provide that all injured persons receive appropriate and adequate compensation. This is what the legislature said. It is not what the legislature did with regard to non-economic damages. One other thing the legislature did not do is to change the common law in this state regarding this type of damages. It is a legitimate type of damages in this state. We do not have classes of damages. Non-economic damages are on the same plane as any other type of compensation allowed. Now, Oregon. A full exegesis of the Oregon Privileges and Immunities analysis is not possible here. But if we accept Professor Schumann's distillation as accurate, Oregon has said if you have a true class, And they divide the privileges and immunities analysis, as you know, into true classes, pseudo classes, and individuals, and provide a separate standard for each, according to the professor. If you have a true class and what is called invidious discrimination, or the alternate phrase being stereotypical